Hello everybody, I'm George from Ireland, so welcome back to my English Law channel. So in this video I'm carrying on with registered land and looking at the different types of interest in registered title. So there are three main types. First of all, there are substantively registered estates and interests, and the existence of these is guaranteed by being on the register. Secondly, there are protectable interests, and if you enter these on the register, then you're protecting them or safeguarding your claim to such an interest. Third of all, there are interests that override, as we now call them, and they can bind even though they're neither substantively registered and they're not protected by entry on the means of register. So that might seem to be a bit of an anomaly. So what estates and interests can be substantively registered? Well, these are certain ones which are on the land registry, and you can see a case called Swift First Limited against the Chief Land Registrar 2015. So the registration of an interest gives the registered owner a guaranteed interest. So to begin with, the only interests that could be substantively registered were legal fee simple and a legal term of years, of which more than 21 years were left to go. But under the Land Registration Act 2002, this has changed because there are more estates which can be registered in that manner, such as we've still got the legal fee simple, legal leases with over 7 years left to run, legal mortgages, for instance, and expressly created legal easements if the servient land is a registered title. Even if the dominant land is not a registered title, that's still capable of substantive interest. It only matters that the servient land is a registered title. The dominant tenement can be registered, can be unregistered, doesn't matter. And also expressly created legal profits. Okay, so let's look at third-party rights. And these, some of these need to be protected by being entered on the register. So this is where contract law leads into land law, because there's the Rights of Third Parties Act. That's why you do contract before you do land. So they used to be called minor interests, and these are all interests which cannot be substantively registered, nor are they overriding, but they can be protected by entry on the register. But notice that they're not substantively registrable. So this is dissimilar to the substantively registered interests. Any entry on the register regarding these minor interests does not guarantee the existence of such an interest. It preserves as a priority against any subsequent disposition. So it makes it at least arguable if you register it this way. So, for example, supposing Arabella, she protects an option, she enters against the registered title belonging to Belinda. Belinda then transfers the title to Charlotte. Charlotte takes the land subject to Arabella's option in as much as it exists. So whether or not that option binds Charlotte, well, that is contingent on whether Arabella's entry in the register and whether its validity can be proved independently. Because it could be challenged by Charlotte. That means that entering the register is a necessary but not conclusive step in maintaining Arabella's option. Okay, so it gives you a chance to maintain your option. It doesn't guarantee that you will successfully maintain it. But if you do not enter it, then you've got no chance. You've got at least an arguable case if you register it. So usually, if you fail to protect your valid option, that means it cannot take priority through the register, even if it could still take priority as an interest that overrides by being validated with actual occupation. And I'll come more onto actual occupation. So apart from this possibility, an unregistered option could be given priority, though it's very rare, by imposing a personal liability on the buyer and creating a constructive trust to try to stop conduct which would be unconscionable, an attempt to deprive someone of his or her right. There are cases like this, like Lias against Prowser, 1982, Lloyd and Dugdale, 2001, Chowdhury and Yavuz, 2011. Right, there are two different kinds of interests in this category, and they are protected by different ways of entering them on the register. So the first one is notice, and that is a mechanism whereby business equitable interests are connected to the land to ensure that they still are maintained through various dispositions if the land is sold or inherited. And that's as per Section 3 of the LRA 2002. The second one is a restriction, and that allows a way to limit what a registered proprietor can do with this land to make sure that familial equitable interests can move from the land to money when it's sold, and that's as per section 40 of the LRA 2002. So commercial and equitable interest in unregistered land can be registered under the Land Charges Act 1972, and they'll be binding if they're protected by an entry of notice on the register, and that's as per section 32 of the LRA 2002. But if they're not protected, they won't be binding, even if the person has notice, unless, of course, is an interest that overrides, and I'll come back to those later on. But anyway, be aware that equity shan't allow a statute to be used as a mechanism for any fraudulent conduct. So the best way is to understand this is if you read Up and Lias against Prowser Developments Limited 1982. Now, it's different if it's a familial equitable trust under section 33 of the LRA 2002. This can't be protected by notice and is not capable of the same sort of protection as commercial equitable interests, but the beneficiary could enter a restriction pursuant to section 40 of the LRA 2002, and that would oblige any buyer to abide by the rulings, by the rules of overreaching. And so, even though a restriction doesn't protect familial equitable interests, it doesn't connect the interest of the land, and it's not binding upon people who buy it later on. The notice does in relation to business equitable interests, and it can be used to protect them. So it gives the beneficiary the ability to overreach, the ability to maintain overreaching, defeat overreaching. So it's much harder to defeat the beneficiary, to get rid of his interests, by obliging the purchase monies to be paid to at least two trustees. So if overreaching happens, that's because the restriction was entered obliging it, or with the purchaser, he abided by the restrictions. Anyway, the purchaser takes the land free from any overreachable interests, for example, familial equitable trusts. Conversely, if there's no restriction and overreaching does not occur, even if the purchaser is bound or not, the interest is dependent upon whether there's an overriding interest. So the crucial thing here is that an overreachable interest will never bind a purchaser who abides by overreaching. Look at City of London Building Society against Flegg, 1988. It only binds a purchaser who fails to abide by overreaching, if it's also an interest that overrides. If you look at William and Glynn's Bank against Boland, 1981, a leading case about a wife occupying a house. Okay, so let's come on to interests that override, and their quondam name for these was overriding interests. So these are registered dispositions, and they take effect subject to those overriding interests, and these are not there on the register. So a wise purchaser will go and have a good look at the land and ask various questions to determine whether or not that the land is buying is impacted by these interests. So it is critical to know whether the third-party interest in the land, whether it overrides, and whether it needs a protection of the register. Interests that override are something which are a bit of a risk for a buyer, because you can't see them on the register, but they're binding on the purchaser even if he never found out about them, even if he made strenuous efforts. You're not paid a penny in compensation if the register is a change to give effect to an overriding interest, because of course the purchaser hasn't lost anything. So you can find some information on the Land Registration Act 1925 about if you look at that, and you'll see how it's changed, the LRA 2002. Bear in mind that section 70 of the LRA 1925 has been junked, and that the 2002 Act is rather different. So those categories aren't law, but people often look at them so they can contrast the current situation. So interests that override, as per section 70 of the LRA 1925, are four major categories. They're easements and profits, and so these are openly exercisable easements, equitable easements. Then there are rights acquired in the process of being acquired under the Limitation Acts. That's as an adverse possessor, a squatter. There are also the rights of every person in actual occupation of land on receipt of rents and profits whereof, save where equity is made of such a person and the rights are not disclosed. And these are... Okay, and then last of all, leases granted for a term not exceeding 21 years. But that last category you still find in the LRA 2002, but it's a bit restricted. Okay, so that's probably enough for the moment. Toodaloo.